Start with this. Imagine a 71-year-old retired school teacher in Ohio. She, we'll call her Margaret, paid into Social Security for 47 years, never missed a payment, never missed a yearly earnings review, never once gave her Social Security number to anyone who didn't need it. She did everything right. Margaret told her daughter, "I have nothing to worry about. The government keeps my records safe. They have kept them safe since 1935. Then, on a Thursday afternoon in June, she opened her mailbox and found a letter she did not expect. The letter said the Social Security Administration had shared her full file, with a federal team she had never heard of. The letter said it was permitted by an emergency court order. The letter said there was nothing she could do about it right now. And the letter told her if she had questions to call a number that, when she called it, rang into an office that could not answer her question. Margaret sat at her kitchen table with the letter in her hand and felt something she had never felt about her own government before. She felt exposed. Stay with me here, because what happened to Margaret is now happening to you. This came from a 6-3 Supreme Court decision issued on June 6th, 2025. The case is called Social Security Administration versus the American Federation of State, County, and Municipal Employees. It is docket number 24 A1063. 6 justices said the government could share your Social Security data right now, today, with a team called DOGE, the Department of Government Efficiency. 3 justices said no. Justice Kagan would deny the application outright, and Justice Jackson wrote a dissent that Justice Sotomayor joined, calling the decision a creation of grave privacy risks for millions of Americans. The dissent is real, it is on the official record, and it is the most direct warning the Supreme Court has issued about your information in years. If you are 65 or older, this story is not a story about somebody else. This is about your file, your number, your bank routing information, your full medical history, your prescriptions, your mental health records, your HIV test results if you have ever applied for disability benefits. All of that was, until last month, protected by a federal law called the Privacy Act of 1974. Congress wrote that law because, and I'm quoting Congress now, the harm to individual privacy from mishandling American information can affect employment, insurance, and credit, among other areas of life. That law was the shield, and on June 6, 2025, 6 justices narrowed that shield to a crack. That part of what I'm about to tell you is bad news. The bad news is real. There is a second part to this story that almost nobody is talking about. It starts on July 4th, 2025, when the president signed a new federal law called the One Big Beautiful Bill Act. Buried inside that law, on page after page of tax language, is a new deduction. If you are 65 or older, you can now deduct an additional $6,000 from your taxable income on top of your regular standard deduction. If you are married and both you and your spouse are 65 or older, that number goes up to $12,000. That deduction lasts through 2028. It can put real money back in your pocket. But here is the part that quietly makes this bad news for seniors starting this July. That deduction is not automatic. It is not mailed to you. You have to claim it. And if you do not know the rules, if you do not know the income limits, if you do not know which forms it lives on, you can lose most or all of it. Worse, in some cases, you can accidentally make yourself look wealthier than you are on paper and trigger a review of your Social Security file at exactly the moment when your file is now exposed to outside eyes as never before. That is the collision. That is what is sitting in your living room right now. Personal data on one side, new tax law on the other, and a court order that lifted the wall between them. Let me lay the whole thing out plain, then give you the protocol at the end so you walk away armed and not scared. First, the ruling. Listen to this part carefully, because most of what you have probably seen on the news skipped over the actual mechanics. On January 20th, 2025, the president signed an executive order, order number 14158. That order created DOGE. It told every federal agency to set up a DOGE team inside the agency and to give that team full and prompt access to all unclassified agency records. The Social Security Administration runs one of the largest data systems in the world. Almost every adult American is in it. Your name, your date of birth, your address history, your bank account number where your benefits are direct deposited, your medical history if you ever filed a disability claim, your prescription records, your mental health treatment records, every one of those is in the file. DOGE staff wanted into that file. The Social Security Administration, following its own rules since the 1970s, normally gives employees only the data they need for the specific job they do. Low-level employees see redacted or anonymized data. Even high-level fraud investigators have to write a written justification before they can pull a single non-anonymized record. That is how the agency kept your data safe for almost 90 years. In February 2025, 2 labor unions and a citizens group filed a lawsuit in federal court in Maryland. They said, the Social Security Administration is giving DOGE staff unfettered access to America's personal data, and that breaks the Privacy Act. On April 17, 2025, the federal district court agreed. The judge, Judge Hollander, issued a preliminary injunction. That's a temporary court order to stop doing something, and she backed it up with a 145-page opinion. She found that the unions were likely to win their case on the merits. She found that without her order, real Americans would suffer irreparable privacy harm that could not be fixed with money later. And she ordered the Social Security Administration to keep using its normal safeguards until the case could be fully decided. The same safeguards every prior fraud review has used for decades. The government appealed. The full Fourth Circuit, sitting en banc, meaning every active judge on the circuit, refused to lift the order, 9-6. Then the government asked the Supreme Court to step in. On June 6, 2025, the Supreme Court, by a 6-3 vote, granted the government's request, paused Judge Hollander's order, and let DOGE staff into your data while the case is still being decided. 3 justices said no. Justice Kagan said no. Justice Jackson said no in writing, joined by Justice Sotomayor. Justice Jackson wrote, and I am quoting the official dissent now, the court is thereby, unfortunately, suggesting that what would be an extraordinary request for everyone else is nothing more than an ordinary day on the docket for this administration. She also wrote that the decision creates grave privacy risks for millions of Americans in the process. Read that again. That is not me. That is a sitting Supreme Court justice on the official docket warning you that your data is now at risk. So that is the ruling. 6-3, June 6, 2025. Your file is now accessible in ways it has not been since the Privacy Act was passed in 1974. The case is still going. The Fourth Circuit will hear the full appeal later this year. The Supreme Court could revisit its decision. But until that happens, today, right now, the wall is thinner. Now, the second front. July 4th, 2025, the new tax law. This is the part that will feel like good news if you are 65 or older, and that is why it is so dangerous. The One Big Beautiful Bill Act added a temporary additional deduction of $6,000 for individuals 65 and older. For married couples where both spouses are 65 and older, $12,000. That runs from the 2025 tax year through 2028. So you have 4 years to use it. Here is the rule, plain. The deduction begins to phase out once your modified adjusted gross income goes above $75,000 if you file single, or above $150,000 if you file married filing jointly, above roughly $175,000 single or $300,000 married, the deduction disappears. Most seniors, especially seniors on Social Security alone, sit well below those numbers. That means most of you reading this right now can claim the full $6,000. That is real money. On a marginal tax rate of 15%, that is $900 back in your pocket. On 22%, that is roughly $1,320. On 24%, $1,440. The Treasury Department itself, on July 14th, 2025, in a public fact sheet, confirmed the deduction and the phase-out ranges. The number is real. The opportunity is real. But here is the trap, and I want you to hear this part twice. The deduction is not automatic. Unlike the standard deduction, this $6,000 does not show up on your tax form without you actively taking it. You have to know it exists. You have to claim it on the right line. If you use a preparer who has not been trained on the new law yet, that preparer can leave money on the table for you and not even tell you. If you prepare your own taxes using software that has not been updated, the deduction can quietly drop out. The IRS guidance from July 14th, 2025 said the deduction must be affirmatively elected. That is IRS language for you have to ask for it. The second trap is bigger. If your income is right at the edge of the phase out, what counts as your modified adjusted gross income can be pushed higher by a one-time event. A required minimum distribution from an IRA you did not need to take, a small inheritance you put in the bank, a capital gain from selling the family cabin. Each of those can push you into a smaller deduction or no deduction at all. The fix is to plan a few $100s of charitable contributions or a direct transfer from an IRA to a qualified charity called a qualified charitable distribution to pull your income back below the line, but only if you know to do it before December 31st. Most seniors will not. The third trap, and this is the one nobody is talking about, is the collision. Because while all of this is happening, your Social Security file is now more accessible than it has been in decades. If anything in that file looks irregular, a typo from 1987, an old overpayment that was forgiven but never deleted, a name change at marriage that did not update correctly, the system now has more eyes on it. A routine IRS review for the new $6,000 deduction can trigger an SSA review of your benefits file. A SSA review triggered by newly accessible DOGE access can bounce back to the IRS. You can be the law-abiding person who did everything right and still get a letter in the mail that says your benefits are being reviewed, that your direct deposit is being paused, that you owe back money for a decade-old clerical error. That is the trapdoor. And that is the part none of them read. You thought the Supreme Court ruling was a fight between unions and a government agency. It was not. It was a fight over who gets to see the most sensitive file about you. You thought the new tax deduction was a gift. It is, but only if you claim it, only if your income stays in the right range, and only if the file behind your benefits does not get flagged while all these new eyes are on it. Now let me back up and give you what you came for. Here is the survival protocol, 7 steps. Plain language. Memorize them. Write them on the back of an envelope if you have to. First, lock down your My Social Security account today before July. Go to ssa.gov, log in, or create an account. Turn on every security feature the site offers. Set up the strongest authentication the site allows. Add a recovery method only you control. Make sure the direct deposit information on file is exactly right. If you do not have a My Social Security account and you are over 65, that itself is a risk. Create one today. The official website is the only safe place to do this. There are fake sites designed to look exactly like ssa.gov. They are designed to harvest your number. Type the address yourself. Do not click a link. Second, place a free credit freeze with all 3 credit bureaus. Equifax, Experian, TransUnion. A credit freeze is free, it is permanent until you lift it, and it stops a stranger from opening a new account in your name even if they have your Social Security number. It is the single most powerful step a senior can take after the Supreme Court ruling. A fraud alert is weaker. A monitoring service is reactive. A freeze is the actual wall. Then, claim the new $6,000 deduction explicitly on your 2025 return. Do not assume your preparer added it. Ask. If the answer is, I'm not sure, show them IRS Fact Sheet FS 2025-03, dated July 14th, 2025, which lays out the deduction in plain language. The fact sheet is public. You can find it on irs.gov. If your tax software is online, confirm it has been updated for the OBBBA changes. Some software rolls out new rules and waves. Refresh the page. Check. After that, audit your income sources before December 31st. If you are right at the edge of the phase out, roughly 75,000 single or 150,000 married, think about whether you want to take a required minimum distribution this year, whether you want to make a charitable gift, and whether a qualified charitable distribution from your IRA makes sense. Every dollar you intentionally redirect now is a dollar that does not accidentally push you out of the deduction or, worse, trigger a cross-agency review of your benefits file. If that happens, if you get a letter from the Social Security Administration that says your benefits are being reviewed, your direct deposit is paused, or you owe back money, do not call the number on the letter alone. Do not confirm anything over the phone to a person who called you. Many of the calls seniors receive in the next 12 months will be real government calls. Many will be scams designed to look like real government calls. Now that sensitive data is in wider circulation, the rule is simple. If you did not make the call, you do not give the information. You hang up. You call the official number on the back of your Social Security card or the one printed on your most recent benefits statement, and you ask whether the contact was real. Read that again. If you did not make the call, you do not give the information. Then read every piece of mail you get from the Social Security Administration from this point forward, not the next day, that day. Small letters, not just the big ones. The most important safeguard you have right now is not the law, it is your own attention. Many of the worst outcomes for seniors in the coming year will begin with a small letter thrown on the kitchen counter, unopened for 2 weeks. Do not be that person. Last, check your official earnings record once a year. The Social Security Administration will mail you a statement, or you can pull one from your My Social Security account. Read every line, every employer, every year. Old clerical errors on your earnings record are the single biggest reason seniors end up with smaller benefits than they earned for 40 years. With the new government access to these records, the chance that an old error gets spotted by someone who is not you has just gone up. Spot it first. If this kind of information keeps you out of trouble, hit subscribe before you forget. Think of it as putting a shield on your side before you ever need it, not a button. A real protection. There is more of this coming. The Fourth Circuit is still deciding the underlying case, and the Supreme Court could revisit its emergency decision at any time. The deduction rules are still being clarified by the IRS as tax software rolls out updates. And a one-line change in how your benefits office reads your file could touch you in ways that do not make the news. Let me bring Margaret back one more time because this is where it gets personal for her. Margaret sat down that Thursday afternoon in June with that letter in her hand and called her daughter, who happens to be a paralegal. Her daughter told her 3 things: lock the credit bureaus, log into my Social Security, verify every deposit. Margaret did all 3 that night. Within 48 hours, she caught a small error on her earnings record from 20 years ago that would have quietly cost her $68 a month for the rest of her life. The fix was a phone call and 1 form. The cost of not knowing was permanent. That is what this July is about. Not panic, not politics, information. Used correctly, it gives you $6,000 you did not have yesterday, a wall around your credit, and a clean benefits file. Used incorrectly or ignored, it strips all 3 away. You now know what the 6 justices decided, you know what the 3 dissenters warned, you know the new deduction, you know the income limits, you know the credit freeze, you know not to give information to a caller you did not call, you know to open the letter the day it arrives.